Okay, we're back to talk one more time about 10 things that everyone should know before
they file bankruptcy.
And this topic is about secured creditors, and people don't understand this enough, and it's something that's real important to understand. I deal with this week to week, week in, week out.
Day in, day out.
Thank you very much. Secured creditors have liens on property. And liens, let's start again, just in case that was buzzing, okay? Ready? Secured creditors, take two. Welcome back, Dwayne here.
JC.
And we're going to talk about a very important topic, and that is how do we address secured creditors? Now, secured creditors are somebody that you pledged collateral to, like, JC?
A car.
A home.
Oh, I get to keep going?
Yeah, we're just a competition.
Oh, jewelry.
Furniture.
Students.
Appliance. Students? No, you can't. Excuse, you got me there. Okay, appliances and electronics and equipment. If you buy a home, you sign a deed of trust, and they're secured by the home. And if you don't pay for it, they foreclose on it and they take it and sell it.
Yeah, I think the easiest way, if someone can take something away from you if you don't make the payments, that's a secured creditor.
Okay.
And I'm not talking about Vinny down on the corner. Yeah. That's a different scenario.
So a secured creditor holds a deed of trust on your home, a lien on your car, a purchase money security interest on the furniture, electronics, appliances, these types of things. Okay. We have, ever since the current law that we use right now has been in place for 115 years. And liens have always been sacrosanct, sacred. There's no way to get rid of liens in a bankruptcy proceeding if the property that you pledged as collateral has equity in it that secures the lien.
So it has value over what you owe. You owe $100, it's worth $200. There's equity in that piece of property.
Thank you for translating equity. So with regard to secured creditors in bankruptcy, you need to understand that you're not going to be able to just file for bankruptcy on your car and keep driving the car.
And not have to make another payment.
Yeah, okay. So how do we address secured creditors? Chapter 7 is a little bit different than a Chapter 13. In a Chapter 7 bankruptcy, if you have a creditor to whom you pledged collateral, you have one of three options. In your statement of intentions, when you file for bankruptcy, you indicate if you're going to
surrender it.
Right.
Means you're going to give it back.
Okay.
And then you don't have to keep making payments because now you don't have the property.
That's right. They've been made whole. They've got their security back in terms of that security interest. A second option is?
Redeem it.
That means to
pay the fair market value of the property.
Oh, that's what redeem means. Okay.
So if you owe...
It sounded religious to me.
If you owe less than what it... I'm sorry, if you owe more, let's flip that around. If you owe more than what the property is actually worth, then you can pay the fair market value of the item to the creditor. There may be a fight in terms of what the actual fair market value is between you and the creditor, but once you come to that, and sometimes the bankruptcy court may be the one that makes that decision, but you pay that amount, the creditor has to accept it, you keep the property, and you're done. That works great with a vacuum.
Yeah.
Sometimes doesn't work so great with a car, where you might have, because if you have to come up with $8,000 or $10,000 in one chunk, if you've got that kind of money sitting around, you're probably not talking to us.
JC brings up my favorite example on redemption, and that is if you bought a Kirby vacuum and they financed it to you for $1,700 and you can't afford to pay everybody anymore, so you file for bankruptcy, you still like the vacuum. The reality is that vacuum on the repossession market is only worth $350 to $400. So if you go into the judge, you file a motion to redeem with the court, and you explain to the judge, you show the judge that vacuum or that car or whatever it is, but in this case the vacuum is only worth $400, the judge can say, okay, JC, you pay the creditor $400 and you'll get to keep the vacuum. You have redeemed that security interest.
You have satisfied the lien.
Because the underlying promissory obligation has been discharged in the bankruptcy. And let me digress a little bit. We still have one more option with regard to keeping properties in a Chapter 7. But let's pretend like I'm holding two sticky notes here.
Okay.
Because that's what I usually use when I'm explaining this to clients across the desk. One of the sticky notes is a promissory note. We promise to pay $1,700 on a Kirby vacuum. We promise to pay it monthly, all the terms, whatever a promissory note is. And it doesn't just apply to vacuums, it applies to cars and houses and everything. The second sticky note is our security interest. It's our security agreement. It says we're going to pledge the vacuum as collateral, and we put those together, and they're just one agreement usually, but it's one piece of paper, but it represents two legal interests. When I file for bankruptcy, we take this first sticky note and we tear it all into pieces and we throw it away because we discharge
That was the promissory note.
our promissory obligation. But we still have to deal with this little sticky note that is the security interest,
Security interest or the lien.
the lien. How do we address it? We either surrender the asset back to the creditor. JC's explained that. We redeem the asset like we've talked about. Or the third option is,
We reaffirm.
which means
you just keep paying what you already agreed to pay.
you take the little promissory note that you had and you either tape it back together, or the easier thing in my example in my office is I take a new promissory note, sticky, and I stick it on there, and you simply sign something that says I'm going to agree to keep paying for the vacuum or the car.
And normally it's going to be the same terms you had before, same interest rate, same payment, same number of
Typically.
months.
Okay.
Most cases.
So when it comes to secured property in Chapter 7, remember, you can't just discharge the debt and keep the asset. You have to either give the asset back, redeem it, or reaffirm on it. Now, Chapter 13 is a little bit different. How does that work?
Well, in Chapter 13, again, if you owe less than, I always get that backwards. If you owe more than what your property is worth, then you can do, it's similar to a redemption in that you're going to pay the market value, but in a Chapter 13, you pay it over time. It's part of your Chapter 13 plan payment. You also have the option with real estate, if you have a second mortgage, we may be able to strip off a lien and get rid of that. So that's a scenario where you can actually get rid of a lien if you meet certain requirements.
In a Chapter 13, you still have the option to surrender an asset or pay its fair market value over the life of a plan. And sometimes, under certain circumstances, you have to pay the total amount that's owed over the life of the plan. But you can keep your secured property. You just can't keep it without addressing the lien somehow. That's pretty much it on secured creditors.
I think so.
Okay.